Today, Justice Edward Belababa delivered his decision on the city's challenge to Bill 5. The judge has ruled that the province's process, which lacked any public input whatsoever, is wrong and contrary to the Charter of Rights and Freedoms. I said at the time of Bill 5 being announced, and have repeated many times since, that you can't change the rules in the middle of a game. That's not fair to anyone, and this is not a game. It is an election campaign, one of the most fundamental foundations of our democratic system. The court has agreed with that, and I think this result justifies the decision of the City Council on a motion strongly supported by me as mayor to seek the independent judgment of the court. That sober second look that I referred to during the course of the City Council debate on the motion. A sober second look away from the political fray and within the context of established law and charter rights held by all Torontonians and all Canadians. Democracy does not belong to a few of us. It belongs to all of us. No law should ever fail to take that into account, and all of us as lawmakers, regardless of where we're carrying out those responsibilities, should always remember that, and we must always remember that. We have stood up for Toronto and for our rights as a city. I've been pushing back against this legislation since it was introduced because I firmly believed you don't change the rules in the middle of an election campaign. It isn't fair, and it isn't right, and it raises the question, what's the rush? I believe it was very clear in July when I said to you here in this place, and I quote, "What I just can't support is change being rammed down our throats without a single second of public consultation." And I went on to say that you don't change the rules in the middle of the game. As I said to Council last month, we take the representation of Toronto citizens seriously. We take the governance of this city seriously. And while we as a municipality must always acknowledge that we exist and operate within the context of the Canadian Constitution, it is our duty to represent the people of Toronto and the best interests of this city at all times, and to make our position clear when we do not believe that the actions of any other government are in our city's best interests. Now that the court decision has been issued, I think it is extremely important that we hear from the Premier and the Government of Ontario and from other Ontario legislative leaders why a reduction of the size of the City Council in the middle of an election campaign is more important than considering any such change, if it needs to be considered at all, at a different time and in a much different manner. A manner that is consistent with the Charter of Rights and Freedoms and which involves the people of the City of Toronto. As I have suggested from the beginning, there are other ways at other times that the Government of Ontario, for right or for wrong, could address this matter, not during the middle of an election campaign and in a way that is respectful of public opinion, public consultation, and the Charter. In short, what is the rush? When you weigh that, the rush, against the very important issues raised by the court. And these are pretty fundamental issues that respect and regard the rights of the people of the City of Toronto. While there are still many questions around the outcome of this decision, right now I believe that Justice Belababa is clear that the election should proceed as scheduled on October the 22nd, under the rules that were set when it began on May the 1st, rules that were in place on that day, and within the context of an administrative process that was well advanced at that time on the basis of a 47-ward system. I want to thank the city's lawyers most sincerely for representing our case so well. The case was entirely argued and prepared by our city staff lawyers, not by outside lawyers, and I want to just say to them that it was a job very well done by them. And I want to thank the other applicants and their counsel as well, because they made important and very much needed submissions that I think put the case in a complete context, and those submissions were very important to the ultimate reasons that were given by the judge. My job remains going forward as it has always been, which is to continue to work with all levels of government, but at the same time to stand up for Toronto, and I will continue to do both for as long as I hold the position as mayor.
With all that being said, Mayor, there seemed to be a belief by a majority of people that this was in fact going to go the other way, that it would be a 25-seat council. So personally, when you saw that ruling come in this morning, what was your reaction?
Well, I think that while I thought maybe the odds, given that the Constitution is clear on the rights of the province to do things as respect cities and towns, which are creatures of the province, that it would be likely that that right to do so would be upheld. I said in my submissions in front of the council, the reason that we have courts and the reason that we now have a charter is so that those courts can take a look at the charter and legislation that is passed and ensure that the legislation is consistent with the charter. And so nowadays, I think I even said this in the council debate. Nowadays, I think you have to expect surprises and things that are out of the ordinary when it comes to even areas that are as clear as the province's jurisdiction to legislate in regard to cities, because they have to be measured against the impact they have on people's charter rights. And I think Torontonians and Canadians hold their charter rights pretty dear, and they think the Charter of Rights is pretty important. And so since we've had one, you get these court cases that say that they think, notwithstanding that the obvious, might be the case in terms of how the Constitution's set up, maybe it isn't so obvious after all.
Mayor Tory, now that this decision's been made, initially the city clerk said it was going to be hard to switch back to 25. Now there's even less time to get back to 47. Is that going to be possible by October 22nd?
I think you'll see that the city clerk will speak for herself in that regard, because it is her jurisdiction and her decision, out of the realm of politicians and political influence and anybody else having comments or opinions on it, to make that decision. The court has said the election should proceed on October 22nd within the rules. And as I pointed out, there was a process well underway on May the 1st to have the election on the basis of 47 wards. And so there was quite a bit of work, I'm sure. I know a lot of work that had been done up to that time. But the city clerk speaks about that, and she speaks about that in her own discretion without interference with or by politicians, with or by politicians.
First, when you're standing here right after Premier Ford dropped his bombshell, you didn't come out charging for a court challenge. You came out saying it was a legal gray zone. You're a lawyer. You're not sure about the chances because we're a creature of the province, and you were talking all about a referendum. So how can you now say that you were somehow leading the charge on this court challenge?
I think you need only go back and look at the record as to what I said on the first day, which was that this was change being rammed down our throats without any consultation whatsoever, and that was wrong. And that's one of the things that the court itself found, that this was being done in the middle of an election campaign, and that's exactly what the court found, and that is what I said on day one. The second thing I would say is that I did take a leadership role, both in terms of calling lawyers in to my office and getting advice, which I passed on to the city solicitor, and in taking a leading role in the debate in saying that we had to go and get that sober second look. I don't apologize for 1 second for suggesting that we could have a referendum, because I think that had the government decided to go that route and have a proper campaign, do it outside of the middle of the election campaign, outside of the election period at all, and get the public's opinion on this after a very vigorous and well-informed campaign, that would have been a better way. And they may even be thinking that would have been a better way to go about this now, given the results of this court case. But, I stood up for the people of Toronto. I did it in the way that I do, and I think that I discharged my responsibilities quite appropriately in that way.
Do you have any sense that the province might invoke the notwithstanding clause and what the city might do if that does happen?
Well, I think that, you might get better analysis from the city's lawyers or other lawyers than from me. But I think the province essentially has three options. Option one is to do nothing and let the court case stand. Option two is to appeal, which I would take no objection to, because I can assure you, had the case gone the other way, we would have appealed. People have the right to appeal under our system. And there is this third option, which is to invoke the notwithstanding clause. I would say, first of all, that has been very rarely done in Canada, notwithstanding that clause has been in place since the advent of our current Constitution and Charter of Rights. And I would really have to ask myself the question, and I think a lot of people would be asking themselves the question, why is it so important to have the changes in place for this election, which was one of the principal bases upon which the judge found that this law was unconstitutional? Why is it so important to proceed in a rush to do that, if you have to make any changes at all, and use the ultimate provision of the Constitution that actually overrides people's charter rights? I repeat what I said. I think the people of Toronto and the people of Canada hold their charter rights very dear. I think they understand the importance of those rights within the context of how we live here in our democratic system. And the notwithstanding clause was put there for very extraordinary circumstances and very extraordinary instances. And you'd have to ask yourself, why does this change, this particular change at this time, qualify as one of those? But we'll see what happens. I can't speculate on what the province will or will not do. They will make their views known, I'm sure, sometime today or very shortly.
Mr. Mayor,
This is one piece of the problem.
Des questions pour le gouvernement provincial sur pourquoi maintenant. Quelles sont les questions que vous voulez que le Premier ministre et le ministre Clark répondent?
Je pense que la décision reconnaître que s'il insiste pour envisager des changements comme celui, cela pas être fait en pleine des élections et devait être confirme la charte. C'est les questions très importantes pour moi. Pourquoi dans le plan des élections et pourquoi dans une manière contre la charte? C'est les deux questions très importantes pour le gouvernement de l'Ontario de répondre.
Mayor Tory, this is one piece of the province's focus on Toronto right now. We already know that he's been talking about uploading transit. How do you think today's loss for the province is going to impact Toronto's relationship with Premier Ford going forward?
Well, I think we went to court, and a court made a decision, and I don't think that should sort of cause people to have any sort of particular political reaction, one way or the other vis-a-vis a relationship. We have courts for this purpose, which is to make sure that when laws are passed by us or by the province or by anybody else, that they withstand the test of the Charter of Rights and Freedoms. That is something that is in place to protect all Canadians and to protect our democracy. And so we have a court case. There is open to the province the opportunity to appeal that decision if they don't like it. But I think that there will be other instances in which things we do may be found to, in some way or other, be outside of our jurisdiction. And what you do is you move forward. My objective in this relationship is not to prove who can throw, how many stones the hardest, or who can, make the loudest and most boisterous statements, or even suggest, crazy ideas like secession. My objective is to make sure we build a relationship in which I do my job, which is to stand up for Toronto, which I believe I have done in this instance and other instances, and I will continue to do going forward. But at the same time, to make sure that a relationship that is one of those fundamentally important to the well-being of the city with the provincial government, whoever forms that government, and with the government of Canada, that those relationships are built up and maintained, because they're very important to us in many respects. And I will take a positive attitude forward to relationship building and to moving the city forward, as I have done in my first 4 years as mayor.
With that in mind,
First noted in his ruling that the
So we'll just go around in order here. And Jeff hadn't had a question yet.
If there is an appeal, how can that timing work with the election? And that'll take us very close to the.
Well, I think people should understand. I'm not going to speculate on how soon or how late an appeal would take place. I think people should understand those appeals don't happen within kind of a couple of days because the court has to find the time to hear it. The parties have to be determined. The submissions have to be prepared. And so I think people shouldn't assume it's in a couple of days. But beyond that, I won't speculate on when an appeal might happen, if it does, or on how that might impact on the date of the election, because I think the first question is not for me to decide. The court will decide that. And the second question is for the clerk to decide. So those questions are better put to her, even though I don't think she answers hypothetical questions as well. She shouldn't.
The city clerk said that she was already seeing so much of her staff overtaxed. Should the city be looking at adding resources to her department to get ready for the?
I would only say to you that if the city clerk told us that in order to carry out a proper election on October 22nd, if that's the mandate that she chooses to follow, then she need only ask for those resources. And I think we gave her, I believe if you check the record in a motion that we passed just before the last full council meeting, I think we gave her very broad latitude to do whatever she had to do, including the resources needed to carry out the election, because we were in such uncharted territory. We really didn't know what might be required later on at a time when the council wasn't meeting. So I think she has fairly broad latitude, but obviously I'm sure we'll hear from her if there's something that the council can do. But again, the decision as to what to do is hers, and that I think is very proper. That politicians shouldn't be making that decision. The clerk should in her own best objective judgment.
Mayor Tory, the Premier's staff are saying you don't want to miss the start of his upcoming news conference. So two questions. One, have you spoken to him to get a reaction? And secondly, when you hear a statement like that, what goes through your mind?
Well, normally, if you said something like that, you'd think it was an unusual kind of, content of that news conference. But I won't speculate on that. I have not spoken with him today, and so I guess I, like you, will await with interest the results of that news conference, and we'll see what happens. But I've commented on, I guess, the three possible outcomes that, and I checked with our lawyers this morning and said, were there any outcomes other than that I was not aware of? And they said no. Those seem to be the most likely three: do nothing, appeal the case, or take other action pursuant to the Constitution. Yes, I'm sorry. I knew there was a voice coming back there. Yes, Tammy.
Looking ahead to the next election, your thoughts on a 25
The next election meaning?
I mean, not October 22nd, 4 years from now, your thoughts on potentially having a 25-seat council, especially considering the fact that you were looking for strong mayor powers?
I have simply said all the way along, and again, I've been very consistent in what I've said. If the province wants to have a discussion, I believe, about the size of the city council, whether we're talking 125 members, 25, 45, 47, I just think that that should be done in a proper manner, and that starts with not doing it in the middle of an election campaign. It goes on from there to say it should be done in a completely open and transparent way that involves the public. I suggested a referendum, which I think would be a very positive idea in light of the fact that any discussion of this kind, as the judge said, represents a very important decision in regard to the rights of Torontonians and the way in which they secure their representation. And so if you said to me there should be a discussion about that, there's been lots of discussion. We ended up at the 47 ward system, and I voted against 47 as opposed to 45. But if you said to me that there should be a discussion, I would say, well, I'm not going to object to that if it's done in a very open and transparent way and in a way that it completely involves the public. But then we do have 4 years in which to do that, and then you might just do it properly. I would point out we had an entire process that went on for some period of time and involved lots of members of the public and lots of expert submissions. In fact, some of those submissions were referred to in the judge's reasons this morning. And so I guess what you would start with is that as the work that has been done, and see from there why you would change the status quo. But if that discussions take place, then it will take place. But I would just hope the next time, as I said this in French, that the next time that there's any discussion about this, if there is a next time, that it be done, first of all, not in the middle of an election campaign. That has been found to be directly contrary to charter rights. And secondly, that it be done in a way that respects the charter and the law that is now set by this case as to how a smaller council does impact on the rights to effective representation of the people of the City of Toronto. Okay.
Paragraph 33 said basically if they'd done this 6 months before, the laws wouldn't have interfered with those charter breaches.
Well, I would say this, and if there are two bases upon which.
It also says, by the way, there's no guarantee to consultation before change.
No, I understand that.
Guarantee that you have to have this consultation, which you have, but there's no guarantee to it.
I completely understand the basis, I think, upon which the decision was made. And it was made on two bases. They were both very different from one another. The first, and this is why it was so important that we had the submissions at court of some of the candidates, because the justice found that the changes to the rules in the middle of the election campaign violated their rights to freedom of expression, because they were left in a situation where they were having to change, what they were doing or react to something in the middle of a process that was well underway. And that would be remedied very simply by just not making those changes in the middle of an election campaign. So any other time that those changes were proposed, if they were to be proposed again, that issue, one assumes, wouldn't exist if you didn't do it in the middle of the election. The second one is more complicated in that it relates to the whole question of what is effective representation, and if you have wards of a certain size as opposed to a smaller or bigger size, how that impacts on people's charter rights. And that decision is one where the judge pointed out that the government failed to put forward any evidence as to why it was reasonable for them to interfere with rights to effective representation that he took as being more likely to be, 61,000 as opposed to 121,000. And he, in fact, used the word crickets, which is an extraordinary word to see used in a decision of this kind to describe the government's case, where they didn't really put forward anything other than anecdotal evidence as to how people could cope with wards of 121,000 and how this would be in the best interests of citizens. And so that clearly puts in front of the government a test they will have to pass, assuming that if this case is not appealed, a test they will have to pass going forward, because that becomes established law for the moment until otherwise determined. And so that's in front of them as something they will have to answer when the questions are asked of them, or when they go some future time forward with legislation, or even go to court.